My lord, what I am respectfully submitting, answer to both of your lords, three of your lords. My lord, if, as distinct from UK and other places, if we have a fundamental right under 14, 19, 21, whatever, to be treated as identical and equal to our other brethren, then the full enjoyment of our rights to be equal to them includes the right of dignified life. If it includes the right of dignified life, which includes the right to choose a partner for marriage or choose a friend or a freedom of expression, whatever we want to express, we don't only mean writing, expression can be, my lord, in love or other forms. And that it is now settled that it is innate, it is not an acquired, my lord, thing, call it queer, call it what you like. If the rights have to be identical, then I must get the recognition of my union the same way as the recognition of the union of two others. And since it is based on an infraction or an implementation of my fundamental right, I can come to the court and the court need not wait for the legislature. And there is a direct passage, my lord, in one of these judgments in Shahraman. So, my lord, I can't keep waiting. There can't be a mandamus to the legislature. Legislature may or may not do. I cannot force the legislature, neither can the court. By that time, our lives will have gone. And our fundamental rights, my lord, will be in name. That there is 5 judgments of the Supreme Court saying that you have the same rights, same panoply of rights, passage after passage. If it is the same panoply of rights, there must be a remedy. And the remedy can only be a declaration to that effect by the highest court of the land, saying that this is a fundamental right. And once it is the imprimatur of this court, then, my lord, it must follow that the state is bound to respect it. Then the society will respect it, and the stigma in the workplace or the public place will then go away, and I'll be able to enjoy, my lord, a unit of marriage, a unit of family. Because that is what is accepted in our society. So in short, I need not wait for Parliament to do what it wants to do, because there can be no mandamus. And then your lordships have said repeatedly, if fundamental right is involved, the doors of this court are open to an individual. I have a right to come here. I have a right to complain that this is what is happening to me in real life. You know, it is happening to us in real life. When we go out, when we talk, when we meet people. Slowly, my lord, it is being accepted because the criminality is gone, but not to its full panoply. People say, what right have you to get married? Which law? Which court? You got a judgment from the Supreme Court in the first one. Where is the second one? So unless and until, my lord, I get a recognition of law under Article 141, because that the other legislative thing is not available to me. Vishakha or whatever. If I have, my lord, a right, that right must be examined by the court, and if found, it must be guaranteed. 32 itself is about of fundamental rights. It must be guaranteed by the court. How will the court guarantee it? My lord, it's not a case of property that your lordship will take it from him and give it to me. Or some money, my lord, taken from me and give it to him. Your lordships will, my lord, give it by a process which is known to law, which is, my lord, interpretation of my fundamental rights, and thereafter interpretation of the law concerned. And then leave it to Parliament that this the court has done. If you want to formalize it in law, as Justice Bhatt put it, if you want to formalize it in law, you jolly well amend the act or do bring a new act, as these countries have done. But if you don't, my lord, the law can't remain static. Law moves, society moves, there's evolution. Rights are different, things are different, thoughts are different. Therefore, the court will act when it is called upon to act. It will do whatever it can within, my lord, its judicial parameters.